Okay. So I think the first thing I've been asking all of the candidates is that, I know this isn't the most crowded race in Nevada County history, but I mean, the fact that there are 5 candidates for this seat is, it's a crowded field. So how do you sort of distinguish yourself from the pack?
Well, there's a number of ways that I distinguish myself. First, I believe I have excellent and well-balanced legal experience. I like to tell people I've worn every hat one can wear in the judicial system. I've served as a prosecutor, I've served as a defense attorney, I've served as a civil litigator representing both plaintiffs and defendants, and I've served as a judge pro tem. 24 years of experience under my belt, doing a little bit of everything, and I think that would put me in a terrific position to hit the ground running as a judge. I know my way around the courtroom, and I would know how to run an effective courtroom. So that's one way I distinguish myself. I am a Nevada County family man, and not all the candidates are, and I think this community wants to have somebody who's proven their dedication to this community. I am a father, I am a husband, my wife's a pediatrician, we have 5 children, we live in Lake of the Pines, we are immersed in the community through sports activities for our kids, through school activities, through civic pursuits. I've served as a prosecutor in this community for 13 years and other communities in Northern California. I've served as a judge pro tem in this community for 6 years. The point is that I've got proven dedication to the community, and I'm immersed in the community, and that's one of the primary reasons I want to be a judge here, is because I want to serve my home community. I think another thing that distinguishes me from the pack is my proven dedication to justice and to the law. I've been a public servant pursuing justice as a prosecutor and in other capacities for some 2 decades. So I've proven that I am here to serve the public. I've done so for decades, and I would love to do so for decades more here in my home community. 2 more things I would point out to you, Liz. Temperament. Temperament matters. And those who know me will tell you that I treat people with respect, with courtesy, with dignity, and with patience, the way they deserve to be treated. And that's an important thing for a judicial officer, because due process isn't just about getting to the right result. It's making sure that people have their full and fair day in court. And the final thing I'd point out to you, Liz, is that I really have the support of a huge number of folks in the community, not the least of which is I have the endorsement presently of 28 separate judicial officers in the region. I'm endorsed by 4 current sitting judges in this county. I'm endorsed by 3 retired judges in this county. I'm endorsed by the entire Placer County bench. I think that says something when the people who are in the business of judging indicate that they know me, they think that I'd be a good judge, and that they stand behind me. So that's how I would distinguish myself from the other candidates in the race.
Okay. You said you have served as a judge pro tem in the Nevada County Court. So the experiences that you've had, in the local courtroom, out through that, what do you see as the particular challenges and maybe the benefits of our court system here?
Well, I think the benefit of our court system is this is the place where some of the most meaningful justice for this community is doled out. And what I mean by that is, this is the place where when there is a husband and a wife who can no longer get along, and there's children who are in the lurch, this is where they all go to have help, to get help with resolving their problems, so they can amicably split up, so that their children can be cared for, and so that this can be done as expeditiously and fairly as possible. It's grassroots justice that has a genuine life impact on members of this community. Another example of a typical dispute or type of litigation that gets resolved here is in our dependency law court. I mean, here you have a child who's potentially neglected or abused, and you've got the life-changing decision that has to be made, that decision being whether or not the parents of that child are going to be able to change their lives around so that they can give that child the parenting and the safe situation that child deserves, or whether the hard decision is going to have to be made to separate that child from his parents and entrust him or her to somebody else. So these are the types of decisions that are just, like I said, life changers for our community, and the types of decisions that I would truly enjoy having a hand in helping the community with.
Okay. What about the very real physical challenges of the current courthouse, and sort of what's your take on what the potential is there?
Are you speaking of the current facility?
Yeah.
And well, we certainly have a facility that is dated and that is insufficient to serve its purpose. There are genuine seismic issues, there are genuine security issues, there are space issues, and those all have to be addressed. My hope is that we can first get some guidance from the current feasibility study that is ongoing, and we can see whether or not it is possible to utilize the current court space to accomplish what needs to be accomplished, which is to renovate the facility so we have a state-of-the-art court facility to serve the public, and possibly do so in a cost-effective manner. We'll have to see what those results are, how feasible it is. If that's not feasible, then we'll have to see if alternative locations are possible. My hope for the community is that we can move that process along as expeditiously as possible, because we really needed our new facility quite some time ago. I don't want to be a Pollyanna, though, in connection with this. This process is, to a certain extent, out of our community's hands, because it is in the hands of the state. The state has a priority list as far as which communities are ranked as the most needy for a new courthouse and which are in the secondary position. We are unfortunately in that secondary tier. It would be my hope that if maybe we can come up with a creative win-win that's less costly, we can convince the state to push us up to that higher tier, and we can get that state-of-the-art facility that we need sooner rather than later.
We were talking about realignment, and you were asking me how that factors into the sentencing calculus. And what I wanted to convey was that while realignment is a serious challenge for a lot of other counties, it is still not the same challenge here, and that's because our county jail, thankfully, remains under capacity. Prior to alignment, we were at 68% capacity. After alignment, we were at 79% capacity, this according to the sheriff. What that means is, because we don't have a capacity problem, we really don't have to, as part of the sentencing calculus, be considering whether or not there is room there or otherwise. We just do the sentencing calculus the way courts should always do the sentencing calculus, and that involves looking at a series of aggravating and mitigating factors. You take a look at the crime, you take a look at the need to deter that individual from committing further crimes, the need to deter other individuals from committing similar crimes. You take a look at the impact of the victim. You look at the question of whether or not there were unique mitigating circumstances associated with the crime. You take a look at the individual's criminal history, whether he's a habitual offender or a first-time offender. And you look at kind of the unique personal characteristics of that defendant, his capacity for rehabilitation, and based on all of those factors, you figure out what the just and appropriate sentence is according to law. Now, realignment, we certainly have to keep an eye on what's going on in other counties in the event that we have some capacity problems in our county. But for now we don't, and for the foreseeable future, it doesn't appear that we will. So this is an issue that while we should study and learn from other counties, we still don't have the same challenge here.
And I think the fact that we house federal prisoners is could certainly become a factor. I don't know. I would assume that the court doesn't really have much control over how the sheriff administers the jail, although.
Oh, that's true. So it's the sheriff's decision, for example, to allow 60 federal prisoners to be housed there out of the maximum capacity, which I believe is somewhere around 285. So that is the type of decision making that's entrusted to the executive branch, and it wouldn't be for the judiciary to tell the sheriff how to manage his jail, so to speak. But I think the important point is that, you know, while some other counties honestly do have significant overcrowding, and judges there have to be cognizant of the fact that there isn't capacity to incarcerate certain defendants who otherwise might receive custodial sentences, that's not an issue here in our county.
The you know, the whole question of how much or whether there's any input the court has in the jail, I think kind of came up last year. I don't know if you followed that whole personal contact, the contact visits issue.
You know, it's an issue that I'm not immediately familiar with. If you want to give me a few details, I might be able to
historically at that jail facility, since it was built, which I think was in the 80s, contact visits between attorneys and people in custody had always been face-to-face in a room, and apparently due to a couple of different issues, they decided at the beginning of this year, was it this year or last? No, I guess it was about this time last year, that a contact visit was going to be accomplished in one of the, you know, the interview rooms with the, you know, the glass
with some sort of partition.
Yeah, with the partition, and their argument was that there was contact because there's a slot, like a mail slot, you know, you can pass documents back and forth. So that's, I guess, currently pending on, you know, on appeal. So it'll be interesting to see where that goes.
Well, indeed. I mean, that raises a challenging issue as to whether or not the partition, so to speak, meaningfully interferes with an accused right, his right or her right to counsel and to be represented and to have a meaningful possibility of putting a defense together. That is, as you put it, a pending matter, so it wouldn't be appropriate for me to comment on it, other than to say that it's obviously a substantial issue of great importance.
Okay. One of the questions that I've been asking both the judge candidates and the DA candidates, because I think there's, you know, even though I've tried to address it in the paper, and I think Judge Dowling actually addressed it in the paper, there's still a lot of confusion about the role of the judge versus the role of the DAs in how, you know, defendants get handled who, you know, do seem to sort of exemplify this whole revolving door problem. You know, they're in and out of custody, they're committing crimes while they're out on bail. You know, whose responsibility is that, and what role does the judge play in, you know, kind of stopping that behavior?
Well, the first responsibility is with the executive branch. It is with the district attorney's office. When an individual is picked up on a crime, it is for the district attorney's office, when it is making an initial appearance or having bail set, it is the district attorney's office duty to present the court with all the relevant facts that need to be considered for the purposes of bail. Once those facts are presented to the court, then the court can decide what the appropriate bail should be, examining basically two factors. What bail needs to be set at in order to reasonably assure a defendant's appearance at future proceedings, and what bail needs to be set at in order to protect the public from any potential danger that that individual might pose. I think the problem that has arisen is that oftentimes there are defendants who are coming into court, and the court knows nothing about that individual besides this is John Doe who's been charged with this crime, and the court's not being given any additional information in order to make a measured bail determination. The truth of the matter is if somebody has been released on bail, one of the principal promises that you make when you're released on bail is that while you are released on bail, you're not going to be committing any further offenses. If you break that promise, that's a very salient fact that needs to be presented to the court. If that information is presented to the court, then the court is empowered to
either raise bail or, under certain circumstances, even deny bail in its entirety. I know as a federal prosecutor, when I go into court, when a defendant is making his initial appearance and is being arraigned, I always come in armed with the complete criminal history for that individual. I know exactly what that individual's ties or not are to the community. I know the details of the crime at issue, and I'm prepared to tell the court, this is why I believe this individual poses a risk of flight, if that's my belief. This is why I believe this individual poses a danger to the community, and this is why I believe bail should be set at X amount. So it is a process that involves both the district attorney's office, the defense attorneys, of course, as well as the court. But courts can only make decisions when the salient facts are presented to them. And the takeaway is that courts do have the discretion for folks who have been out on bail and who have been creating further crimes while they're out on bail. Courts do have the discretion to raise bail or to revoke bail, and there might be circumstances under which that is totally appropriate if someone has proven that they are not a reliable risk while out on bail.
Okay. Sorry for the choppiness of all this, because I feel like we just started this whole interview up again, and I'm ready to wrap it up. But is there anything that I haven't covered, or maybe a question I haven't asked that you think is important for people to know about you and maybe about the race? I mean, why should, and this kind of maybe is being unduly I don't know what the word is, but why should people care about who is their judge? I mean, that seems like an obvious question, but I don't know really how much the general public thinks who the judge is really makes that much of a difference.
Well, the reason they should care is because judges are making important decisions that have a genuine impact on people's lives. And you do want to think long and hard about the question of, some people don't want to think about this, but just pretend for a moment that you are named as a litigant in a civil lawsuit, or your child gets in trouble with the law, or you find yourself in family law court. I think people want to reflect upon what type of judge they would really want to appear before and have handling that matter. And if you find yourself in the situation in which you do need to resort to the courts, and a goodly number of our people at some point in their lives will need to do so, I'd suggest to you that you really do want to have a judge who is going to be fair, who is going to be thoughtful, and who's going to be respectful. And you are going to want to have a judge who has the requisite experience, who has the sense of the community, who has the right temperament, in order to fairly and thoughtfully handle your disputes. So it does matter. And I would humbly suggest that I've got the right stuff to be the type of judge who would make the community proud, and in whom the community could place its trust.
Okay. Any last words?
Folks might be interested in knowing, why it is that I want to be a judge. I don't know, but it boils down to about 4 or 5 separate things. First of all, I very much love the law. I believe in the rule of law. And I want to be a part of sustaining the vitality of our legal system and the fair administration of justice. So that's huge for me. The reason why I want to be a judge is because this is my hometown. This is my community. I've got long roots here. I'm going to be here for decades to come, and I'd very much like to serve my community and continue my public service career. I think a related reason why I very much want to be a judge is because I do really treasure public service. I love
serving the people, helping people. It gives me a great sense of personal accomplishment and a great sense of meaning. It's a big part of who I am. And then the other two things I'd point out to you, Liz, are I love doing justice. I've put the rope on. I've tried it out. That was a really important part of the process for me to figure out whether or not I like being a judge, because not all advocates are cut out to be a judge or even like the task of being the neutral umpire. And I love it. I love the process of sorting through complicated factual situations, figuring out what the applicable standard is, and coming up with that kind of nuanced and balanced solution to a problem, and helping people who are oftentimes faced with some problem. They're at a crossroads or they're at loggerheads, helping get that problem resolved so people can move on with the rest of their lives. That's a big part of what justice is all about. And then, the final reason I'd suggest to you is that I'm interested in being a judge is because I honestly think I'd be a very, very good judge. I think I got the stuff to thoughtfully and to fairly and to respectfully hear people out, to figure out the facts, apply the law, to decide the cases only in accordance with the law and the facts, and ultimately to ensure people that not only that they've got a judge who's made a fair decision, but to ensure the litigants that they've had their full opportunity to be heard, which is equally important in the process. So that's the only additional pearl that I would throw out there for your consideration.
Okay, great. Thank you.
You're welcome.
And thank you